Hello friends, welcome to our channel Steno. Subscribe our channel for more dictations on daily basis. Get ready for the dictation without any stop. In our view, it is not necessary for us to express any considered opinion on the question as to whether, in view of the provisions of Section 18 of the Andhra Pradesh Tenancy Act, the suit before the district municip was maintainable. We shall assume in favour of the appellant for the purpose of these appeals that such a suit was maintainable, though we express no considered opinion on that question. Assuming that such a suit was maintainable, the question is whether the relief of permanent injunction by way of equitable relief ought to have been granted in favour of the appellant. We have earlier noticed that the appellant himself had invoked the jurisdiction of the authorities under the Andhra Pradesh Tenancy Act seeking eviction of the respondent who was his tenant. Though the eviction application was allowed by the original authority and the appellant was put in possession of the shoot land, his appeal was dismissed and an order was passed for restitution. It was at this stage that the appellant invoked the writ jurisdiction of the High Court to stay the proceedings, and when he failed before the High Court, he filed a suit for injunction for restraining the respondent tenant from interfering with his possession of the shoot land. In fact, the suit for injunction was filed with a view to defeat the process of restitution which followed the appellate authority's order. It is now sought to be contended by the learned counsel for the appellant that the tenancy courts had no jurisdiction and therefore the order of restitution also has no force. If we accept the contention of the appellant that the order passed by the tenancy courts at his instance is without jurisdiction and void, then in equality the respondent should be put back in possession of the land in question so as to obtain status quo ante, because the appellant himself obtained possession of the land by executing the order of eviction passed under the act at his instance. We are satisfied that equitable relief of the nature asked for in the suit in question should not have been granted in favour of the appellant so as to defeat the order of restitution passed by the revenue authorities under the Tenancy Act, whose jurisdiction under the Tenancy Act was invoked by the appellant himself. The appellant cannot be permitted to retain possession by challenging the order as being without jurisdiction, particularly when the jurisdiction was invoked by the appellant himself only because the ultimate order has gone against him. The grant of discretionary relief, such as injunction, being in the nature of equitable relief, must be granted inter alia on considerations of equity and justice, and the appellant, who is himself guilty of inequitable conduct, cannot claim such relief. Therefore, we find that in the facts and circumstances of the case, assuming for the sake of argument that the civil court had jurisdiction to entertain the suit, this was an appropriate case in which injunction ought not to have been granted.